Time to. Okay, was it gonna play twice? Good morning. Y'all. Charge it to my head, not my heart. They got me up at 4 o'clock this morning, adulting, as you can see, which means I had to be out by bed by 3:30 this morning to go ahead and tend to me. And I'm just now getting to my coffee. So please, that just scared the hell out of me. Sorry. Hey, Twitch. I'm like, am I talking back to me? Oh my God. I can't believe that. Mm, mm, mm. Listen. All right, so we're getting ready. So we got a couple of things going on today. Couple of things besides I'm apologizing now. I've been up way too early, okay? Thank you, perfectly flawed. As you can see, if I am a little loopy. I know everybody usually have a 3 p.m. crash, but since it was about 3:30 a.m., I'm thinking that crash gonna happen by now. How and ever be how. I have both going right now, Hannah, so you don't have to do anything. However, we're going to try to analyze in this space, watch in the other space. Oh, I went to go see Wendy last night. Oh, can we see? Can we see the light is like super bright? Oh, we went to go see Wendy last night. And my toes are yellow because it's spring. I don't know if anybody else ever feels like me, but I have never, ever in my life made a New Year's resolution. I have never felt moved to do anything new or exciting besides my birthday in January. However, spring has always been that oomph for me. I always start something in spring. And by start, I'll be like, in it, research, producing, I swear, spring, like that blooming of the flowers, the earth coming back to life. That's me. That's when you'll catch the color. That's when you'll catch the spring cleaning. Like I get all that in me, like mamas know, like nesting. Okay, y'all know what was it last year or the year before when we first got together? I was dumping I snatched everything out my backyard and left it bare. Backyard is coming together, okay? We just need new seating for the fire pit. We got a new table on the patio, enclose the patio, and then we have a table outside of the patio. Yes. What else did we do? I think y'all were with me when I took my one-car garage and turned it into. No, ma'am, don't subscribe. You don't have to subscribe yet. I think subscribing just changes the ad situation. So no, we don't have to do that. I think most of you guys were with me. Was it last year when I took the one-car garage, dumped it out from all my candle stuff, and I made it into a playroom for the boys? And then the two-car garage, my garages are split. So the two-car garage over here by the office is like hodgepodge. It's wheels in there. It's two sets of wheels in there because y'all know we got a problem with wheels. So it's two sets of wheels in there. What else is in there? But also in there's a deep freezer, the refrigerator. It needs some order. Okay. So all things pertaining to the house and living will be going over into the one car garage. So that's going to be Big Unc, aka Santa's workshop. Okay. He didn't got all his tools. He didn't got a new craftsman chest, and then he got the part to go on top of that. He didn't got all these shelves and stuff. So he's been working on. That's why I heard like noise back and forth. That's what he went to go pick up off of Facebook Marketplace yesterday, some more shelving. So, no, Rail, we don't. Not all the way. Everybody been real good about saying, hey, it's me, such and such. So we have to, so Big Unc's been working on making that Santa's workshop in the one car garage over here. Also over here on the back elevated part of it, it's like a little step. That's where the refrigerator and the other refrigerator and deep freezer, we're going to put that over there because it's much easier because that garage comes into the living room, right? So that's much easier. We're going to do that. That's what's been going on around here. That's why I missed damn Sharon. I missed Michigan because I was out there in the backyard getting shit together. Then the 2-car garage is getting dumped out. Wheels are getting moved, and I'm parking Kia Bia in there. I ain't parked in my garage in 6 years. That's terrible. I should be ashamed, but I'm not. Because I'm getting it together. What Pop say? The condition of your things is the condition of your mind, and the way we are getting it together, baby. Now, Montresa, I'm about to be blowing your line up. Don't tell me what to do because I've been trying to get me a green thumb. Have y'all seen Tiff's plants? I think somebody got Tiff Ann that, yes, you coming through, Alex Lulu? I know your name is Alex Lulu, but it was there. It was bars. Sorry. No, we can't. Not yet. Perfectly flawed. Not yet. I think we have to go live over there over 6 more days. So, I'll let you know when and how. Congratulations, Caitlin. Congratulations. Oh, and in the springtime. Oh, baby, you about to be running around like what was it, the Road Runner? Like me, you can be I get it. I get it. Now, after I get this, the next project is my car, because y'all know I refuse to give up my car. I do not want a car note. And I literally had this car when I bought Dallas home. I'm sorry. I don't have to keep up with the Joneses. My Kia Bia, her bumps, her lights, all of that. But the Arizona sun has tore her up on the top, on the hood. If y'all ever see anybody that live out this way and live on the sun, it tears up your paint job really, really bad. So I have been tussling back and forth with whether or not I want to get it wrapped, because I guess I'm just giving y'all all the business this morning. But there was a time when Kia was doing a lot of recalls and things of that nature. And since I had my car, they had to do a whole lot of work. And so basically everything under the hood of Kia Bia is new except for the transmission. They have dropped a new engine, new starter, new everything. Only thing I had to pay for was the belts and hoses. And of course that was like $200-300. So of course I got all new belts and hoses. And then y'all see where I'm at every day. I don't drive. And when I do go somewhere with my husband, I'm a passenger princess. So Kia Bia is good. Okay. So I just want to, that's the thing. I was like, at one point I said, okay, I'm turning 40. Remember last year? And I was like, I want my big girl car. And I saw them big girl car notes, and I have not had a car note in a while. And I thought about all the other things I can do, i.e. plane tickets, just popping up at folk baby shower and stuff. I I just rather go do fun things with my kids and pay $600-700 a month in a car note. Also, I don't like the back of cars anymore. Do anybody look at all these new cars? Why do the back of cars, the new cars, the new SUVs? I was thinking about getting like a small SUV because, Big Unc drives an Avalanche, and I'm thinking, why all the back of the cars look like they got desk booty? Just flat and wide, like they just no walking and just. Now I am into cars, Hannah, but cars that are actually from the 80s and not like that line yesterday. If I can get me like a 84, 85 Caprice painted all black with pink glitter skunk stripes. Babe. I know. Yeah, so yeah, Kia Bia is right here. I'm looking at her and she ain't going nowhere, baby. She might get some new feet. She might get some new shoes. Don't do that. Don't do that. Cupcake sham wow, don't play. Now y'all know that woman was lying. I think she was saying like she was living her dreams. It's not as hard as it may seem, okay? Because sometimes I think that might have been when she jumped off the porch. You know what I mean? That might have been her college years, something like that. Because I'm always very, I forgot, only 5. I was in the middle of making a post for TikTok. Yeah, I'm thinking those was her college years. Maybe that's something in the 80s. It got to be because I refuse. I absolutely refuse. Because, my college years was like 03 to about 07-ish, and, that was like Kings of Kronk. And, that's when Keisha Cole had the little ketchup with the mustard on the top. Pretty Ricky was coming out with stuff that made us feel like we was real grown. Monica was knocking on doors and kick down your door and smack your chick. Pastor Troy had some stuff going. Master P was running in place with his good niece. There was a Freako Leak, a Pop Lock and Drop It. And then it was a new improved hood hop to make every this bitch do the wop. Okay? Like that was a time, So if I say something about the early 2000s, I need to make it clear that was the time when I was outside and not the time when I was born. She should have said she was outside in the 80s. Yes, Destiny. I had to be on camera real early this morning for the Philippines. I know. I try to take a break. I'm drinking coffee and we're live waiting on court to start. It's Tiffany and Destiny, y'all. No, you're on my glasses. They can't hear you. What, packing? Oh, yeah, you playing. Well, at least you got a real 2 weeks. Because, every time I say I got 2 weeks, it's not 2 weeks. At least I'm not flying out in the morning because I didn't have a thing out. Yes, on Twitch, I heard.
On the record in 231.
Here we go.
139, State of Utah versus Kouri Richins. Counsel for the state and the defense are present. Ms. Richins is present. May we begin by confirming whether or not there's any legal discussion we need to have regarding the text message excerpt that the defense offered during cross-examination of Detective O'Driscoll at the end of the day yesterday.
Yes. Yes, Your Honor, I think we do. May I stay seated so I can read my,
Of course.
okay, just 1 second. Let me pull it up.
If we can all look at it at the same time, I appreciate it, Katie.
Are you pulling up the Celebrate one? Or okay.
Yeah, I got
So,
the meta
it's
glasses
up
for
on the
Big Unc
screen
for
right
his
now. So it
birthday
starts with Bates number state
and got me some too.
STATE 0335281. And this was produced to us before the state went through and updated the time. So this is on UTC time instead of mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, anyway, hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrite extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrite and extracted by Miss Gibson.
Can you show me the Cellbrite
Yes,
version
sir.
of
We
this?
are. We can. We're pulling it up right now.
It's a very big file. So what I've done is I've emailed Katie the cover page, and then I'm working on the box download so she could download
Yeah.
it.
Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right.
Typically, these are a complete string that has a Cellbrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Celebrite header. Only some of them,
I
not
don't
all of
know
them.
if is that true. I thought
That's
all of them had the
No.
Cellbrite header.
That is not true.
Hold on, let's pause there for a second, because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, we've had CDR related metadata regarding text messages. We've had some non-bubble related or non-bubble depicted cell messages that have come out of other extractions. But in terms of blue and green bubbles, I thought all of them had a Cellbrite header.
Yeah, I believe that's right, Your Honor. If we prepared an exhibit that comes from a Celebrite extraction, it has the Celebrite header.
Right.
There's others where we just, we've got texts from other means. Somebody sent us, forwarded us text, right?
Right.
But if
Screenshots, for example.
correct,
Yeah.
if it comes from a Celebrite extraction, as best I recall, it has the Celebrite header.
Okay. And Ms. Nestor, I'll give you the record back here in a second, but it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th. So it's from the 3rd.
Okay. These 3 bubbles are the sum total of their text traffic on the 3rd?
We have more than 3. There's just a minute. There's a couple pages to it. It's the last set of texts that they, there's multiple, see, that's the 2nd page. And yeah. And that's the last text that they had between the 2 of them before.
Can you go to that one, please? Katie, can you blow up the 3rd one on that sheet? So As I understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yes, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the daytime information is inaccurate.
Well,
Correct?
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected. And I would expect for the Celebrate downloads that we have authenticated and laid foundation for, the time change is baked in.
Consistent across the board. Right.
So the fact that this is still in UTC -5 instead of UTC -6 or 7 just caused me to question where this came from, which Celebrate download it came from. And I still don't know.
So that brings us to, is there a version of this that has the Celebrate header?
that's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No problem.
It's very long, so we have to go right to it. Just give us just 1 minute.
No problem.
Okay, guys, are we hearing
Oh, you
what Miss Piggy is trying to do? Do we got what Miss Piggy is trying to do? So where did these messages come from? And I'm wondering if these came from a phone that Kouri got rid of or duplicated or put her back, you use the Apple ID and did the backup because, okay, so remember yesterday they ended. All right. So remember yesterday, y'all, we ended with them attempting to bring in some text messages. And before we got to the text message, they said, okay, let's stop for the day because there was going to be an argument about these text messages, right? So apparently it's not just one excerpt, it's actually pages, according to Miss Nestor. Let me not call her Miss Piggy. I think I called her a fool yesterday. I need to stop. So what Mr. Bloodworth is saying now is, where did these come from? This ain't that. This ain't what you saying it is, because see, the Celebrate download has Ursula looking at. See, we gonna keep doing it. The Celebrate download already accounts for time zone, time switch, UTC, however it was done. So all the text messages that were pulled from the phones when they were dumped from Gray Key and then stuck in Celebrate all have the same time and situation on them. But here she come with some time messages, with some messages, and the timestamps ain't been shifted like it would have been had it been through Celebrate. So where are these messages coming from? How did you get them, and how did they not make it through the Celebrate? And so what Bloodworth is saying is, could be text messages, or in the words of Mr., could be not. Because had it been through this dump, had you pulled it through what's already been verified and stipulated to and authenticated as the Celebrate dump, the time wouldn't be off. See what she's trying? But she's trying to say these are definitely text messages. Could be, but how'd you get them?
on a Mac? Oh, God.
And we know Kouri good for changing the header on something. Allegedly.
Our millennial
I
has a
digress.
Mac, so it may take a second.
Well, this discussion doesn't need to be had with me on the record in front of everybody. If you can have it with each other first, and
figure out if he's going to allow it in, and I'll be saying, hell no, we won't go.
regarding foundation,
Yeah.
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we could work parallel while they're
You're over on Twitch giving
looking at
shout out.
foundation information. we could address, well, a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's further objection is that it's beyond the scope of the direct.
Let's handle those one at a time.
Okay.
Ms. Nestor, regarding hearsay, your client's statements are hearsay if they're offered by you.
Right.
Eric Richins' statements are categorically hearsay if they're offered for the truth.
Right.
What is the non-hearsay purpose of these particular text messages?
So we are actually not interested at all in what is being said, and we could do an instruction to that, excuse me, to that effect. What we are trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd. And that was sent the day before. That is connected to the GIFs, whatever you say, that all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called witnesses about it.
Provide a little more context. What is the photograph of and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever. And he sends her a picture of it while he's there before he gets home that night. That is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning at 8:40 as soon as the police leave. And they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're trying to explain to the jury. All I care about is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs.
She did bring it up, y'all, but she did not bring it up like this and did not try to bring in these text messages. What she tried to say is that you don't know if, and it was Ramos did it. Remember, Ramos went and got his phone and was like, I just said this. Then I looked at this. Then I pulled up 2 pictures and put them in there. Now I added another one. But you mean to tell me when you dump my phone, it's going to look like I looked at all 3 of them at the same time? It was Ramos. It wasn't her. Remember, Ramos did that? So that's what she's trying to prove now. Good morning, Tiffany. But that's exactly, oh, wow. That's exactly what she's trying to say now. She's trying to say now, all of a sudden, they have the text messages that proves that these were sent between Kouri and Eric the day before or his last day on earth and not her. Remember, it was, what's the guys from Dumber and Dumber? Harry and Lloyd. Remember, it was Harry that was like sitting in the bed with the money, crying into the money, and they are basically saying she was celebrating the fact that Eric was gone and she was in the money. But they said that she didn't access him till the next morning after he was dead. But what the defense is trying to say, no, her and Eric sent those messages to each other the day before. And maybe trying to imply that maybe she felt like she was in the money because she was closing on the Midway Mansion. We got it. Y'all just know she gonna talk in circles and she gonna tell you a whole lot of words and don't say nothing. But they're saying orphan gift because of the way that it landed in the dump. It doesn't show exactly where it goes to. It's in the dump. It was in the phone, in the deleted files, but it doesn't show exactly what message it was attached to, which could also look like it was deleted.
The exact same time, and it was sent the day before. And that's all we're trying to do. We don't care about what's in the bubbles. We can black out what's in the bubbles. I don't care.
Why are you doing this through Detective Driscoll? Why didn't you do it through Mr. Katradimos? I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see he sent her a picture the day before? The rest of it we'll do separately.
But that's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why defendant believes it's relevant, and I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any of the metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri? That's all I'm asking. Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture. That's all I
Without the
care
metadata,
about.
the picture is not relevant.
Well, the
You need the date and time.
We have that. No. We do need the date and time, but I'm talking about the, I thought there was more information on the bottom of those things. And we can
Why are
take
we
that.
doing this for Detective O'Driscoll rather than through another witness that can testify regarding the
You just
relationship
asked that.
between the file path for the GIFs and the file path for this photograph?
Because he reviewed it and saw it. I mean, I think he can testify to it.
You can't testify to any of the technical relationship that you're asking for.
Correct. And we're not asking for that. That's all we're asking him is to say that the picture was sent the 3rd. That's all I need him to say. And he knows that because he reviewed it. So he's capable.
He knows what he saw. How does
Right.
he know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so
But that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it? I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that this witness has foundation to give you the testimony you're asking for. What's the question you're going to ask?
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said, yes.
Okay. And then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm
Is
not
that-
asking him for
I'm
any
not sure that's
technical.
even in dispute. Go ahead, Mr. Bloodworth.
Let's never come out before on any other witness.
Okay. But go ahead, Mr. Bloodworth.
I didn't have anything, Your Honor.
Okay. Is there any objection to him just saying yes or no to that question?
If the yes or no to the question of did he review Eric Richins' text messages from the
I think that's already been answered. Yes
okay,
or no.
yes. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
And so if
Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph, Ms. Nestor?
I do want to publish the photograph.
And tell me why the photograph is relevant?
Well, that photograph is already in as part of Exhibit 340, which
It's not in, but we've stipulated.
we've stipulated is coming in next. But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in
We've stipulated to it. It's about to come in.
through.
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What,
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see on, I still think there's a hearsay problem based on counsel's explanation. Now, I also think there's a relevancy objection. The photo that we've been discussing,
The gravel photo.
the gravel photo, was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publication's the hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
I'm not sure that follows without additional context. Just sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the defense has, the defense is, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping phone.
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died? Yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd? Yes or no? Yes. Is this the photograph that he sent? Full stop.
Oh, I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh no, fair enough. I'm not telling you how to testify, and I don't know what he'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand? Do we have a common understanding of the limits of what you can ask Detective
Absolutely.
O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't. It's too hard for him to. I mean, I think it needs
You
to
can't
be.
show the text messages without provoking the hearsay problem.
No, not to the jury, just to refresh.
Oh, that's
Because I think it's got to be. He's not going to know. It's just going to be a weird picture.
understood.
Should we just go ahead?
Are you
and
going to publish the photo to the jury though?
No.
Oh, okay.
So, we could just go ahead and admit 340 now, because then the next question is going to be, is this the same photo that is in this picture right here? And then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now there's the follow on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
So
it.
is
I'll do
somebody
it.
going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
That's fine. We do have one other issue. If we're resolved with this, I think we're all clear. I know what I can ask, what I can't. I think we're fine.
Okay.
There's another issue. May I bring it up?
Please.
All right. I really need Officer O'Driscoll to leave the courtroom when we talk about this, because it's
Oh.
about specific questions.
No problem. Detective, if you take a step into the lobby, please don't talk to anybody while you're out there, sir. Thank you.
Okay. Thank you, Your Honor. I'm doing this out of an abundance of caution to avoid any potential. I'm trying to be very careful to comply with the court's ruling on the motion in limine that, or not the motion in limine, the motion to admit the statements of David Norris. So
Not.
correct.
Yeah.
Our motion to admit that was denied.
Yes.
So just to make the record, the defense sought in advance to get approval to, or actually we gave notice to the state that we intended to call a witness named Mr. Norris, who would testify if called, that on an occasion in 2019, I believe, in 2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl. He had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Or for Kouri, but
Correct. The court did, the reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
the residual.
The residual, I'm sorry, I call it catch-all, same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand to testify because the residual hearsay exception requirements were not met. It is my desire with this witness to ask him the following 4 questions about his investigation. And it touches on Mr. Norris's testimony, but it's a separate matter. But I just, out of abundance of caution, I am giving you a heads up. So the first question is this. You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got it right.
I'm sorry. I do have these if you want me to email them to you.
No, it's okay. Just give me a moment.
No worries.
Was it prior allegations that Eric?
Any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Got it.
And this is the next question. Within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about about an incident where Eric allegedly asked someone for fentanyl? Want me to read that again?
Sure.
And within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl? And then there's one more question. Let me know when you're ready, Your Honor.
Sheriff investigative team. Give me the last clause one more time.
Who wanted to share with the investigative team information
That holds the weight
about
for
an
me,
incident
like
where Eric allegedly asked someone for fentanyl.
the book being sent anonymously.
Final
This is the
question
real
is,
Kouri.
do you or anyone
I'll
else
buy
connected to
it.
the
I'm
investigative
not buying it.
team
What y'all think
ever
about
sit
that?
down with this individual and talk to them? Did you make any efforts to see if this individual was credible or had corroborating evidence to back up their claims. And that's it.
Mr. Blood.
No objection to the first question. Objections to the next three. This is a transparent attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible. This setup has been long in the making. After the court issued its 807 ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him, and he said he was calling on behalf of, or he was calling because defense counsel told him he should call.
Maybe we just pause here for a moment. I don't know that we need to go into any of that. I understand part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I think that's the beginning and the end of the discussion. There's no foundation for the premise of your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
I'm sorry, but I don't understand what you mean by there's no fact. There is validation from the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. There is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded, is someone contacting you, asking to give you information about it, and you refuse to interview them?
That's not the question you asked. Read the whole question.
In order to properly investigate,
No. Go to number 2.
that is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask it this way. What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
That's a fair question.
It would be reversible error for me to allow that question.
Ma'am.
There were 2 residual exception rulings in this case. Let's be fair about it.
Right. That's absolutely correct. So is there a way, if we scrub out the reference to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here. If we just said that an individual contacted them with information.
Why are you bringing up anything about this
interaction
individual?
with
If
Eric
they've already been
involving
excluded and never
drugs,
touched the stand, why would you be able to ask
street
about them?
drugs, and they chose not to investigate it at all. It does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all other possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can
Exactly.
possibly get in.
Fair enough.
But I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed. And they are like, no, thank you.
Who
I think I'm
does
entitled to
that?
come in, and I'm willing to do it.
Why on
the
God's
most
green earth would I
ethical,
say,
careful,
hey,
reliable,
I'm a rug
non-influential
dealer
way
and I'm
possible,
calling
but
you
I do believe
because
that's
he tried to get
fair game.
rugs from me? That sounds like somebody being
And
paid
I'm
or
open to
promising to be
suggestions,
paid if she gets the trust back, if
whatever
they
we
just
need
go
to do.
take the heat off of her.
These 4 questions are not it.
Just gonna rat on himself. Come on.
You look like you're about to say something else.
No, Your Honor, as I understand the status quo is the court's, I guess this court has.
Hey,
sustained
over
state's
here, I
objection
sell
to
rugs,
this
and he was asking me for
I
some.
think what Ms. Nestor is trying to
What?
work off is another set of objectionable questions that may be more general, less specific, some version of probing the bounds of.
Ma'am, you sure that was real sugar you put on your cornflakes this morning? Because it sounded like it was booger sugar.
investigation
You have
of
lost your
the
mind.
charges.
Your Honor, no, it's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative
Yes,
has been
Amanda.
so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may be admissible evidence.
May I respond?
Yeah, hear me out for a second.
Sure.
Or let me make sure I understand the balance of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record so far, and the evidentiary record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence that's already admitted
I think it's his knee surgery,
is
right?
a 2016 hydrocodone prescription following knee surgery.
Right. Okay. Very good. Now, by the same token, I believe all the admissible evidence of Ms. Richins seeking or receiving narcotics of any type is already in. Correct? And Paul is putting it strongly, but
Yeah.
that is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
Or it would come in the rebuttal case.
Understood. Okay. Which was the basis, among other things, of not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. Right. So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you were accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis
Yeah, my ass up.
based on the law of the hoops you have to jump through to come under the residual exception. And for purposes of your analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true. And then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not. So I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
The difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office or Sheriff's Office? My apologies.
Yeah.
He says, yes. And then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely.
And
we don't.
if you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on, fine, but I'm not sure how that's relevant.
Well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
But it's not being offered for the truth. It's being
100%
offered,
being offered.
Your
for the
Honor,
truth.
if I may please, it's being offered for the same reason they've gotten in a ton of other hearsay in this case, by the impact it has on how they did their investigation. They got that in through
Her
Woody.
favorite. You
That's
let
how
them
they
do
got
it.
in Woody, the Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out. This is the same exact argument. It's how the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor, then
Yes.
the 807 residual exception wouldn't exist and it wouldn't apply. It does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why the substance of what he told the Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy
Leave out
question
what?
and
Because
just
it's
say
a
there was
dealer
an
calling the
avenue that you
sheriff's
chose
office
not
to
to
say, hey, that
investigate.
man died
But
from
I
rugs
gotta
trying to
give
buy them
something
from
in
me.
context so the jury understands, hey, you have
So what
this
are you left
road,
with?
you chose not
I
to go
called the
down it.
sheriff's
It was your
office
choice.
I appreciate
to
why
tell
you
them
want to
something
present this to the jury, but
about
there are limits
somebody?
on both sides of the V about what gets presented to the jury, and those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence for the same reason that the state could not argue that we want to get in Hayden Jeff's statements to his sister just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about
No!
choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it, would we be having this conversation?
That's not this circumstance, though.
It is the same, though.
It's the
because
same.
That evidence has nothing to do. Here, it's even worse because it's inadmissible.
It's inadmissible from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance is inadmissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant, but without the substance, it's not relevant.
We have just a moment.
Why does everything travel to your brain by boat? If it was ruled out that nothing about Norris can come in, Norris can't testify, Norris can't be a part of shit, why are you trying to get Norris in here and try to claim that you're not doing it for the truth of the matter asserted? You are trying to get in some truth about Norris. And Norris is a damn fool if he about to let you come in here and say he a rug dealer. And what you can come to a conclusion about Norris with is that he on rugs if he comes sit in a court of law and tell all the ways he breaks it. Just like you thought, what's her name? Carmen was gonna come in there yesterday and say, yeah, I broke all this since 2023. I do not recall trying to catch somebody up with another charge.
Okay, Your Honor, I think we've made our record on that, and I'll, of course, respect the court's ruling on that.
You don't have no choice.
Let me take a minute. Let me just take 5 minutes.
Thank you, Your Honor.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before we invite the jury?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay, I'll be right back. Thank you.
All right.
Probably need to go back there in the back and punch the air and have a drink dealing with her. That's ridiculous. So if you didn't catch what just happened, Nestor is trying to draw a line between one, she's trying to somehow get the lead detective to say, because he's the lead detective, he should actually be the end all be all and know all of all things this case, as if he actually did every single thing a part of this case by hand himself with his own 2 eyes, ears, and hands, and walked with his own feet. Now, we know that this investigation or any investigation is going to have moving parts. There's somebody for digital forensics. There's somebody in the lab doing testing. There's an ME. All these parts, but see, somehow in this case, Nestor doesn't think any of that happened. All of this had to be done. The testing of samples, the collection of evidence, the going through the GPS spots, going through the call logs, all of that had to have been done by O'Driscoll. And since Miss Nestor thinks that everything should have been done by O'Driscoll, now she wants him to have an answer for everything, even though there are things that he did not do. So, as with any investigation. So, not only does she expect him to know every GPS point of Eric's phone the day before he passed, whether or not his phone ever went past that Midway house where Carmen was dropping off the rugs 2 and 3 times during any of those times of transactions, whether or not he wants her to know she wants him to know everything, including those 3 pictures that they said that Kouri looked at after Eric was gone. And she wants to put in that her and Eric sent those messages while he was still alive, the day before he passed. So instead of her being able to actually talk about that with somebody, say like digital forensics, who can tell her about that, she expects O'Driscoll to be able to not only answer whether or not that was a text message in his phone, but whether or not the text message in his phone was seen between him and Kouri the day before he died and not after he died. Ma'am, if somebody sent me a text message right now, ain't no way I'm all the way alive and they can't tell you whether or not I looked at it today or I didn't see it until in the morning. Sometimes my phone got over 1,000 notifications on. You think I look at that shit? So she's asking him questions he's clearly not going to know the answer to. She's asking him questions that she clearly should have asked somebody else. And then on top of all that, she goes and talks about somebody who has been ruled out. Their testimony has been completely ruled out for the basis of residual hearsay, period, point blank. This person never touched the stand. They've never been brought up in front of the jury. And somehow she wants to be able to ask questions like a bitter person leaving subliminal posts on Facebook. What? Now, this person is David Norris, and David Norris is allegedly, and I'm going to say allegedly because at this point, David Norris better be Casper the Friendly Ghost. He better not exist. But David Norris allegedly called the Summit County Sheriff's Office and said, "Hi, hello, my name is David Norris, and I'm a rug dealer, and Eric tried to buy Fenty from me. Why? I would not be surprised. And I'm going to say allegedly because I don't have not one leg to stand on with what I'm about to say. But I would be more inclined to believe that Ronnie or DJ called that, or somebody with a male voice. And at this point, it could have been her mama with a male voice, since she's sending books, and said, hey, my name is David Norris and I sell rugs, and Eric's been trying to get rugs from me. Like, y'all doing anything. I guess this lands depending on how you took that walk the dog letter from yesterday. If you truly believe that all she was doing was jogging her brother's memory and said, please tell them about what you know, because that's going to exonerate me, then that's one thing. The walk the dog letter came off to me personally. I am not nobody when it comes to this, but it came off to me as if she was trying to say, since it's upon information, since it's on believe that. Tell them that he told you this. Tell him that he said that. And I do believe she was getting ready to manufacture a story because shit started hitting the fan. When she got arrested in May, maybe it wasn't that serious. Maybe you could laugh about a sandwich. But after you start spending days in that jail, and then weeks, and then weeks turn into months, from May to September, the leaves that start falling off the trees, the seasons are changing. It was getting ready to get real cold in that summer, bitch. You realize this might be your life. And I do believe you said, wait a minute, if they can just make it, because they could be making up the shit about the sandwich. I'll give you that. So I do believe somebody would sit there. I would probably, as a human, sit there and say, well, if they can make up sandwiches, what's two men watching football? If they can make up we were beefing, why wouldn't he tell my brother not to tell me? You see what I'm saying? So I don't think the walk the dog letter exonerates her. I think the walk the dog letter makes her look worse. And since the walk the dog letter came out right behind her mom doing anonymous Amazon drops, and then after that, we're at, hi, my name is David Norris and I'm a rug dealer. And this man that just passed from Fenty tried to get it from me. What you gonna say after that? I didn't give it to him? Because if nothing more, that would send the dogs and the cops up to your house to check and see if you got the Fenty. And if you got some, what's to stop them from saying that? It's your Fenty that took him out. Like, why would you ever do that? Who would ever do that? I believe that was Ronnie or DJ. Just my personal opinion. Oh, I need to move my sign over here. I'm going to put it right here. Allegedly. Oh, no, I just switched everything around. Allegedly got to come over here with me. Hold on, guys. We got to bring allegedly over here, baby, because I can't be saying stuff and not have my proof in the background. Ooh. We're gonna put it over here. Allegedly. Oh, don't make a liar out of me now. Put it up here. Me and these nails. Okay. Hold on. Now, I know I said that we were going to take this particular, I just figured out how to stream to this other TV. This is usually my other trial TV, and then, of course, the one right there that I pull out. But I think, and I think my third TV is going to go on that one. But I am going to do a bit of a whiteboard digitally. I think next trial we're going to put up a whiteboard. It does still say January. My outside one says March, but that one still says January. Is it? Yes. Oh, well, hold on. Let's turn this one off. Okay. Yes, it's The Simpsons. The Simpsons be telling us stuff. You know. Oh, I listen. My other one is up to date. I need to redo that one. Only problem is this, and this is why I was looking into a new calendar, because this one isn't like my other dry erase one. This one I actually got to get the stuff out and spray it down, wipe it down, and clean it. The other one I just take my little eraser. So much easier. Plus the other thing is oh God, I need to get a digital one. It's like I have a running note over here. Oh, we had a birthday. Did I miss a birthday? Melissa Carrion. March 2nd. Did we miss a birthday? I knew we had the 21st, 23rd, 27th. Am I tripping? Oh no, that would drive me crazy. But what I have been doing or practicing doing, we'll try it. I'm gonna try it some more this weekend. But I'm gonna have to take it out of here. But I know I got my iPad in this little case that make it like a little laptop, right? So I can cast this to that. So I have it's over here somewhere, my little iPen, a little Apple pen. And I'm like, if I can go ahead, create me a little whiteboard situation, and we actually draw on it with the pen, but it comes up here. Take this out the circle, put us back on a rectangle so we can see it. We can keep that up and then cast, and with that always being up in the background, and we can also take what's on this iPad, because it connects to everything, because it's Apple. So to be like a fourth screen, we can actually drag it from the iPad and actually put it on the screen as well, so we can see it. So we can keep it up here, add to it during testimony, and then show it. Why am I in a circle? It's just on circle for some reason. I don't know. I think it happened when I put the background up there. Yep. That one episode, we even gonna talk about that episode. Oh, we can't talk about that episode, but that episode, I know what episode. I know what episode, honey. Oh. Hold on, guys. I got something I need to fly through. And yeah, it didn't come back through yet. I think Jamal Bryant should have ran that by his wife. That's just all I'm gonna say. That's all I'm gonna say. He should have ran that by his wife. Pissing people off. That's what he's doing. That is what he's doing. Let me see. I think it has something to do with. Is this it? Okay. There we go. But then if I do that, then it takes me to orange. And we was like somewhere in here. So maybe. So you got me touching stuff. Okay, we'll take that one and that one. There we go. He has called a truce between melanated folk boycotting Tarjay. And he said it's over. He said it's over. Tarjay has paid, made amends, put in on some things, and therefore we should be good with Tarjay. Tarjay should be good with us. And it's like, sir, you didn't start that boycott. So you can't tell people when to stop. And just because somebody sprinkles some money on something, that just further lets you know that they didn't find value in you until they started losing the value of themselves. And not about the value that they think about themselves, the one in their pocket and bank account. And since they did not give a until their coins were affected, that don't mean that our coins are respected. They didn't think enough of that melanated coin to not do what they did. That was not a factor. That was not a part of the consideration when they started making the moves that they did. So therefore, you don't get to come back like Nesta and say, well, all I'm going to ask is, all I'm finna say is, I just want to say one thing. Because you could have said it in the beginning. It shouldn't have took you this long to figure it out. It shouldn't have took you this long to say it. And the reason why you just now figuring it out because it actually did come through your dang on your pockets. Your pockets is sagging like bad boobs. It ain't as perky. That account ain't as perked up as it used to be. And now you feeling it. And now you think, oh, maybe we should get them back. And if the way to get them back was to go ahead and put a couple dollars in it anyway, then you could have kept them dollars in the DEI that you cut. Now, I'm gonna say this though, Miss Sheila. I do understand Tabitha trying. I do understand why she would try because she was actually directly benefiting from that. So I do understand those brands that were there, like Tabitha Brown or like the Lit Bar and things of that nature that I use. Right? They like, hey, you boycott them, you leaving me with no dollar. Like they really gonna kick my product out because who else about to get it if y'all don't come in here and get it? So I do understand from a business standpoint, it's like, don't boycott me. I'm here. I'm represented. So I understand that. But baby, I'll go and you better go and put your seasons next to Lawry's. I'll just go get some Kinders somewhere else. I don't need the sunshine season. And I was cooking before it. I'll cook after it. So you have to. It just was a. Everybody suffered with that. Everybody suffered with that. I love you back, Destiny. What happened? Nicole singing. So What is this? Now that's a little more than 5 minutes. But let's do this because then I stop a couple times.
State versus McCullough, 2014 UTF
Come on.
versus McCullough,
Okay, here we go.
2014 UTF 215. Need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeff's statements to his sister. Pause for a second. I need you all to be very thoughtful about this. I can't unring the bell once this information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Bon Savage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me. Oh, I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement into question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do?
How do you know it was David Norris?
This statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. And I'm not sure Detective O'Driscoll's that guy. By the same token, to the extent the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or information received or told by Mr. Bon Savage, they're going to have to call a witness that had personal knowledge of those statements and then laid foundation for what occurred next. We can't skip steps.
Your Honor, agreed. There's a little more to unpack here too, because I happen to know that Jeff O'Driscoll's not the witness for this. We would need time to prepare the witness for this. we also have the problem that
We meaning
the state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point,
Mhm.
imagine it's not Jeff O'Driscoll, as
Right.
you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris, or they call David Norris.
Sure.
And they ask, did you
Sure.
call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to information regarding the Hayden Jeff statements and the Nick Bond Savage statements, that would come in the state's rebuttal case. Is that correct?
Not necessarily, Your Honor. I mean, we haven't rested. I think we
Fair.
would like to get out in front of this
Okay.
before a rebuttal case. And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about. And the state would
Come on.
continue that investigation.
I think I know what you're talking about, but in terms of how it came to be that David Norris contacted law enforcement when he did,
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you,
Yeah.
I don't think so. My only point in mentioning that is it would just take a little bit of time and it would be necessary. The other point, I think, well, the other objection the state has is under 403. I think in proceeding in this manner, it's both prejudicial and confusing the jury.
If I let in everything, though, so Norris, Jeffs, Bond Savage, does
Mhm.
that ameliorate any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope of law
Sure.
enforcement's investigation, not for the jury.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both that assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think
Honey.
because of the
Because baby, red glasses got the look. Because what?
complete incredibility of David Norris's testimony and how David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than confusion related to recorded interviews with Hayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't, David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect, just because the information provided to David Norris is highly in doubt and would be highly litigated, whereas the information Hayden Jeffs provided is recorded. There is zero doubt about what he provided. And the information that Nick Bond Savage provided is recorded. There is zero doubt. We're not bogging down into some mess of who said what when.
I get it.
When you say the information, you mean the substance of what David Norris told Summit County Sheriff's Office a number of weeks ago.
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Mm.
What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once he spoke with a patrol deputy to take kind of the initial, well, I guess there's once a call into dispatch, which was non-substitute.
Okay.
Then there was an initial
The
contact.
jury is waiting.
And then there was a contact with the detective.
But I get what he's saying
And
about,
we have
even though,
documents that he'd submitted.
so think about what he's saying though, y'all, for real. If they let him bring in Nick Von Savage, which we know that was Carmen's Rowley, and we didn't hear nothing about, we haven't seen him, right? And then Hayden Jeff's sister, remember they bought Miss Isbell in, who was Hayden Jeff's significant other for years. Remember, Hayden Jeffs passed away in a motorcycle accident, and they bought the girlfriend in, and it was through her. They said that Baynard was intimidating her via text about not wanting to testify or prep before testifying. So basically, there's some conversations that Hayden Jeffs actually did a recorded interview. Nick Von Savage has a recorded interview. Nick Von Savage has some jail calls attached to him as well. Hayden Jeffs might have a call too. But what Mr. Bloodworth is saying is that, hey, what Nick Von Savage said is what Nick Von Savage said. What Hayden Jeffs said in that interview is what Hayden Jeffs said in that interview. There's no reason to argue about it because what was said was said. We got it recorded. Ain't no question about it. But see, Mr. Norris, his shit's not recorded. And see, what I'm going to do is get up in here and it's going to be highly litigated, meaning we finna tussle. We finna tussle. And I'm not stopping until they hit the ground like Egypt Chris. Okay, I'm not stopping until no, we tussling about this because he don't never say the same shit. His shit change all the time. It don't matter if we got an affidavit about what he said the first time, it's gonna change again as soon as he talks to defense. And I'm gonna keep tussling. And that tussle might make it look like to somebody, a regular human that didn't know no better, that why you tussling so hard if it ain't true? Why you not paying? Like, why you so mad about him? Why y'all keep going back and forth? And that may unfairly or prejudicially give his testimony and what he's saying way more weight than what was already been said, and can be played, rewound, and played again by either Hayden Jeffs or Nick Von Savage. And so therefore, he's gonna mess around and look like he's more credible. I'm with you. I don't trust no rug dealer that gets so high he telling himself.
That defense is submitted in the 807.
She got the shit knocked out of her, didn't she?
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Just to clarify, they weren't affidavits. We just laid out a statement of facts in our motion.
Okay.
It's a proffer.
I'm familiar with what you're referring to. I'm a little less clear on
Sorry,
that. Yeah.
proffer is, proffer is the.
I'm not sure the proffer has any impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
Your Honor, the proffers do tie into this in that, the question would be, did this inform your investigation? Yes, we considered all of his statements to include the defense proffers in determining that they were just flat out incredible.
Okay.
So that goes to kind of the confusion argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is the same as the weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
And to put a finer point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need.
It's jury confusion.
Right. And
Yes.
so what is it you believe they would be confused about?
I think they would. I think they would be confused about the effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of
You're
Norris,
right.
whereas
Can't
those
trust
waters
the
are crystal
crackhead.
clear in the case of Hayden Jeffs and Nick Bond Savage. And the waters are muddied as it relates to Mr. Norris. Very
I've
deliberately.
been looking for a hold on.
And that and I don't know. I suspect the purpose is to confuse the jury, right?
As you sit here today, have you identified the witness that would testify regarding investigators' knowledge of and response to statements made by David Norris?
I know. Yeah, I don't remember the name. I know the patrol officer. I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right? And so
You would be able to call an investigator, not a lawyer, right?
right.
Yeah.
So probably 3 witnesses.
Okay. And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Hayden Jeff's statements to his sister? Or, I mean, I appreciate that Hayden Jeff spoke directly to
It's on.
law enforcement in a recorded
They
interview.
haven't started yet, but it's on.
Right. That's what we would have to get into. What did you understand? Why? With what level of detail? Which is extraordinary.
And there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, judge, there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nick Bond Savage jail call, right? That entire jail call comes in lock, stock, and barrel. If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice? I think the court, in considering the weight of the various
Yeah, they haven't bought.
prejudices, the prejudice.
He's not in there yet. So Jarvis Butts is being sentenced today.
Versus the prejudice of.
They have not bought him into the courtroom yet.
I think the court needs to I guess in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence. And
Is that him coming in?
that David Norris's assertion is not at all probative, because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case. Whereas the Bond Savage statement and the Hayden Jeff statement is highly corroborated with a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation and probative value to the state's response to that theory.
Correct, under the 403 balancing.
I understand your position.
Okay.
Ms. Lewis, Ms. Nestor, Mr. Ramos, this is high stakes poker.
Yes, it is. I was just going to ask you, if we could have a little time to meet with our client next door, she's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the substance of David Norris's statements should come in not for their truth, but for their effect upon law enforcement and investigators,
Mhm.
their probative value to the defendant's theory.
Yeah, this is about to go on break.
Or, incompetent investigation.
He ain't in there yet.
By extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Hayden Jeffs and Mr. Bonsavage, not for their truth, but to show what they were doing and how they were doing.
Can I just get a clarification on the Bonsavage? I want to make sure I'm on the same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Yes, Your Honor. In a March 4th, 2022 jail call between Mr. Bonsavage and an inmate in Gunnison, they're discussing purchasing a PlayStation controller, and they're discussing who's going to pay for it, kind of how to get the money for it. And Nick Bonsavage says to the inmate something like, Carmen will cover it. She just made money selling fentanyl.
So this is already in, other than we
The word
substituted the word fentanyl
We
for
illicit
illicit
street drugs.
street drugs.
What is happening with the damn camera? Did the camera
It is
fall?
recorded.
As is Hayden Jeff's interview with law enforcement.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I explained to her, in really colorful language, how dangerous it is. She wants to stay away from it. Who on earth would want fentanyl? And then there's a second phone call where she calls back and asks for the Michael Jackson stuff, and they get into a propofol discussion.
Okay. How much time do you want, Ms. Nestor?
We have 30 minutes.
That's fine.
Thank you, Your Honor.
Anything else before we take a recess, Mr. Bloodworth?
No, Your Honor.
Ms. Nestor?
No, sir.
We'll be in recess until 10:30.
All right.
All right. So while I'm going to scoot this up so that we are back live for that one. And then they still have not started, but we'll flip over. It looks like they're about to bring him out. Up, hold on. It lost the sound. Let me do it again. He has to give a truthful statement about the baby. No, she's still never been found, Miss Sheila. She's still never been found. This is the sentencing. And let me put I think he has to make a truthful statement. Now, whether he's done it in or out, I'm sure it has to go on the record. From what we read in his deal, he has to give a truthful statement about her body. Now, there have been rumors out there of two things. One, that he may have already gave a piece of a statement that says she was in that river where remember where the clothes were found and that shoe was found and her hoodie and it had the DNA inside of the hoodie and things of that nature. What are you doing? Refusing to come out? Y'all better come on here. But that has not been confirmed. Other people have been reporting that they must find her in order for him to get his deal. I did not see that in the black and white, so I'm not going to hang my hat on that. I wish that were the case, but I have not seen that. The other things that have been reported that I don't know if we're going to find out, but I would hope to find out today is there have been rumors alleged that Shannon has been provided immunity, no other way to say it, in order to testify against him. Of course, we know he didn't take it to trial all the way. Like we state, like we discussed in the preliminary trial, I did say that I felt like he was going to use Naziah one last time to save his own ass, and to me, he did. I believe he was. Let me go back to our notes because we did talk about this. So Jarvis's plea deal was. Let me see. So each of the cases that he had open. So what was it? 6 cases. Each of the cases that he had open for each person, right? They were all those criminal, you know what kind of conduct, either in first or second degree, depending on trigger warning, penetration, or age, right? So all those charges that had the CSC plus, you know, like a, what was it, like a second offender notice. One had like a commercial activity attached to it. Basically, all those got thrown out, and he got one CSC per victim, or we'll call him survivor. One CSC per survivor, right? But when it comes to Naziah Harris, remember Naziah Harris, he was actually being charged with a first degree premeditated M. That actually got bumped down to second degree unaliving. So his charge allowed him to plead guilty to one CSC per case, including Naziah. And then instead of first degree premeditated homicide, he got to do second degree, which takes away the premeditation. They also threw out or completely removed any habitual offender act, which we know he impregnated someone that was underage. I believe she was 13 or 14 when he was 19. So he didn't already serve 10 years behind it, was allegedly on the phone with Naziah's aunt as she was a kid during this sentence. So he never learned his lesson. He continued the same, and people have allowed him to continue the same. So he was a habitual offender long before Naziah Harris was a thought. But he does not have to. They did throw out the habitual offender charge, which would have gave him a mandatory 25 years. So basically, all of the charges were like, I don't even remember what the number was, but people were coming up with these astronomical numbers. But the thing is, he did plead to up to 15 years for each of those CSC, so all 6 of them. But the thing is, they're all to run concurrent. So the clock starts on every guilty charge at the same time, and he's been in there for a little while. The only charge that's going to run the longest is for the second degree unaliving of Naziah Harris. And I believe that is 25 to 30 years or 25 to 33 years, something of that nature. And so, okay, he must be getting ready to come out because they telling him no cell phone. So basically, the longest time he could get is like up to like 33 or 35 years. Um, and he has to give a slap, a slap on the wrist, and he has to give a truthful statement about Naziah, about her body. He's not to have any contact with Annette or Naziah's family, and something else. But basically, he's going to have an out date. Pounding? What the heck? What's going on? That was my thing, Manda. How will they know if it's true? How do you know if it's true? And then if it implicates people that you offered immunity to, do they get charged? This man was supposed to be on the offenders registry and just wasn't checking in 4 years. Nobody did anything. But somehow everybody everywhere that comes across him knows exactly what his history is. He has more victims than I've ever heard of in my life, and nobody says or does anything. And these women keep with children, keep talking to him and being with him and having more kids for him. Yeah, morning. They sentencing um um Jarvis Butts today. Remember I told you they let him take that plea? The text messages you couldn't listen to.
Oh yeah.
Big Uncle almost got sick off them text messages. He said, I got to get out of here. He talking to a kid. He couldn't watch the preliminary. Come on, Sharana, bring that bastard out. He shouldn't be able to, and he better be walking straight. They better not let him wear that damn mask. They say, hey, Big Uncle.
Been popping out on my Snuggie since they talked shit the last time.
He said he popping in with his Snuggie since people talking shit.
Since y'all was talking shit about my Snuggie, I'm gonna pop in. What's up?
Kids still sleep.
Mm-hmm. You never hear me say that, so wait until he calls. At this point, call and say, hey, I'm in the airport or I'm in the air or something. I want to do something with that damn.
Got the nerve to be standing straight up. They need to snatch that mask off his face. Oh, I got this over top. I know he was reading the other part.
He ain't looking.
Huh?
He trying to look so like he's sick or something. Somebody, on YouTube. Sure. I don't want to get you no straight.
Well, listen, we already on punishment on YouTube.
All right, good afternoon. Calling cases 25000218, 24002-236, 24006-232, 2500241, 25004-478.
All of them.
25006-461.
Just say all the
All in the matters of People versus Jarvis.
Those is all kids.
Yeah.
Sentencing, can I have appearances? Can we start with the prosecutors?
Good afternoon, Your Honor. Tina Ripley on behalf of the people, P83688.
And good afternoon, Your Honor. Matthew Mathis on behalf of the people, P827.
They got the death penalty on the table.
They don't have that Michigan. And no, they let him plead to second degree.
Oh, he in Michigan, so not. Yeah, all right.
Good afternoon, Your Honor. Lori Butler, P8126, with the Defender Service, also on behalf of Mr. Fox.
Thank you. Mr. Bucks, please state your name. All right, thank you. Attorneys, you can all have a seat if you'd like.
No, use your big boy voice you be using back there and you be using on the phone.
Mr. Bucks matters. His cases did resolve short of trial rendered pleas with sentence agreements on all 6 of his files. Noting, of course, there's a lot of people in this courtroom. I want everyone to look around at all of the gentlemen and ladies wearing the brown uniforms. If anyone thinks, if you're thinking you cannot.
Fox 2. Are you kidding me? Oh.
And follow the rules of the court and behave in a civilized manner, now would be your time to exit the courtroom. I will not, or I will take it very seriously in the event of any sort of outburst, and I don't want to see anything like that. We all understand.
That's the barring type right there.
All right, attorneys.
Why they got him
as
up
noted
for like tried to go drive on the foot like they did the other guys. He ain't fast enough to do nothing.
I'm like, y'all got to switch positions. Put him by the door.
Yeah, put the white dude up front. At least he or physically fit. The dude ain't doing. He ain't chasing up but a donut.
Pre-sentence investigation report discuss some potential changes or modifications to the sentencing guidelines. So I'll start with the prosecutors, and one or both of you are going to.
He looked like he was in Beverly Hills 90210.
Yes, Judge.
Yeah.
Very good. Were you requesting any additions, deletions, or corrections?
Not to the body of the report. I don't know if you want to go through those first and then do the guidelines.
We can start with the body first.
Nothing to the body of the report, Judge.
Okay, and that includes Ms. Ripley's files as well?
Yes, Judge.
Okay, thank you. Defense, have you all had an opportunity to review the pre-sentence report and contents with Mr. Butler?
Yeah.
And were you requesting any additions, deletions, or corrections?
There are some changes, yeah.
Okay, very good. Whenever you're ready, counsel.
All right, the first change is going to be on the body of the report, page 1.
Every time I look at that defense team,
Yeah, I'm sorry, it's page 3. Where it lists the currently under sentence, sentencing date for that charge should be 2/4 of 24, not 2/4 of 27.
Okay. We'll make that change. What else, counsel?
And you are my client, just one moment. Under the section on the evaluation of plan, it would be paragraph 4.
Give me 1 moment to get there, counsel. Evaluation plan, paragraph 4. I'm there.
My client states he has never resided in Arizona, nor has he ever told anyone to reside in Arizona. So I like that stricken.
People?
No objection.
Let's strike that portion of the sentence, counsel.
I just want to hear that judge life. We're off the movie.
Mm-hmm.
And it is going to be number 5 of 21.
What page are you on, counsel?
I am on page 19.
5 of 21?
Correct.
Yes, there.
My client indicates that he was never originally charged with 2 counts. He said it was always 1 count that he was originally charged with in that matter.
So what? They taking habitual offender off. Shut up and take it. Like you just see, give them an inch, they take them out. They're already not charging you with the extra 25 years. You're supposed to get off rip. And now you want them to fix and correct
Under
shit.
page 4,
Can you see?
under 4 of 21, the CCW. You know, I'm sorry, that's the wrong one.
Just gotta.
On page 25, 16 to 21.
16 of 21 on there, counsel.
The sentence was actually 2 years probation with first year in Wayne County Jail, not 3.
People dispute that?
No, Judge.
All right, we'll modify that to a 2-year term of probation.
Okay. Next changes would be under the merit section, page 29.
In there.
We need to delete Danielle Dinwiddie as a child, as well as Christopher Dinwiddie. These are not Mr. Butt's biological children.
Okay, Danielle Dinwiddie should be struck.
Right, yes.
People agree?
Yes, Judge.
Christopher Dinwiddie needs to be struck as well.
People agree?
Yes, Judge.
Okay. And the listing of Davion Markel Butts should actually be Davion Pettis is his last name. Pettas.
Pettas.
Yes.
I'll be raising my hand. Take my name off as his kid too. I don't want to be associated.
Going to the previous page, page number 28 under family.
I'm there.
We need to add a brother, Naeem, N-A''IM, Butts. This brother is deceased.
Here, we'll do this. I'll try to reshare it. See if that helps the sound.
No objection.
Okay. Next change is going to be under substance treatment. This would be page number 33 in the report.
I'm there.
Okay. Under Catholic Social Services, it shows completed no. That should be completed yes. Just one moment. They completed that no, but he is added that he completed that.
All right, the leads you completed the Catholic Social Services outpatient treatment.
Yes.
People dispute that?
No, Your Honor.
I'll change the no to yes, counsel.
And Your Honor, that is it as far as changes to the body of the report. The only change to the guidelines would be the guidelines under case ending in 2436. Yeah, we'll let the people start and we'll put our change after this.
Okay, very good. All right, Mr. Makepeace, you were requesting some changes to help guidelines report.
Yes, Judge, and I'm just gonna go in the order that they were listed in the PSI.
Appreciate that. I'm on the first one.
And that would be case ending 2236.
Yes.
With respect to the PRVs, we believe those are correct. The OB, the only changes on the OB should be OB 12, which is scored at 5, that should be 0.
OB 12 is scored at 5. You believe that should be 0. I presume no objection from the defense.
No objection, no.
All right, we'll change OB 12 on that case number to reflect 0.
And that reduces the total OB level to 35. It does not change the OB level or the guideline minimum range, 43 to 86 is correct.
All right. Is defense requesting any additional modifications to how the guidelines are scored on that docket number?
No.
All right. I'll change the total OBs to reflect 35. OB level remains the same. Guideline minimum range remains the same, about 43 to 86 months.
Yes.
Okay. Thank you. All right. Next.
That would be case ending 6232. The PRVs are correctly scored. The same change is being requested of OB 12 from 5 to 0.
That's we waiting to see if he gonna talk.
No objection, Your Honor.
All right. OB 12 will be changed to 0. Any other changes to that, Mr. Makepeace?
Not the OBs. That reduces the total OB from 50 to 45. It does reduce the OB level from 5 to 4, and it reduces the guideline minimum range of 43 to 80, from 50 to 100 to 43 to 86.
Okay. Does defense concur with that?
Yes, Your Honor.
Okay. And were you requesting any additional changes to that docket number?
No, Your Honor.
All right. I'll make those changes.
Okay, so
45. OB level of 4. Guideline range of 43 to
All right, guys, here's what we're going to do. While they're getting their paperwork together, we're going to let them have that. We're going to jump back over because Kouri has apparently made a decision about whether or not she want to try this shit with Mr. Norris. So we're going to see what they came up with, and then we'll see what they do after that. We'll try to move along so we don't end up stuck with paperwork or a whole lot of trial, because I know this other trial is Mountain Standard.
Ms. Richins.
So I have both of them up, but as soon as they get
Thank you, Your Honor.
get off
Thank
of
you for
the
break.
dockets,
We
we'll go
appreciate
back.
that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation.
You'll never lay foundation, so
Officer O'Driscoll, he's outstanding. He is not the foundation witness because he is not the individual who communicated with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask the questions that he doesn't have, because it's like you said, there's no way to
you
ask
just
the
wasted
question
our
without
time.
introducing the substance. We couldn't figure out how
You
to do
just
that.
wasted everybody's
So we're
time.
gonna wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
They're still going over
And if we decide to go forward.
the dockets on the other side.
I agree
Wasted
with that.
everybody's
If
time.
You make that ultimate decision.
We'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense.
Kouri's collars look like it came with an old school Steve Harvey suit. I
Clearly
just can't take no
summarize
more.
on the record their strategic balancing of the risks and benefits so that there is a record of that going forward.
I appreciate that, and I think that's probably a good idea for everyone,
Okay, very
including
good.
us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay. So, as a matter of status quo, we are going to proceed with additional cross-examination of Detective O'Driscoll, correct?
Yes, sir.
Did we reach I'm sorry.
Could we just go ahead and, well, I can just do it through, I think we decided I'd just ask him about 340. I'm sorry, nothing, I apologize. I
Okay.
withdraw.
I was about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan is to introduce the stipulated 340, which we'll get in. And then I will ask him if he can identify the photo. If he can't, he can't, but I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce the bubbles or any of that.
Okay.
The only thing I'm going to display to the jury will be the picture on 340. And then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
Only the date.
Eric and Kouri on the date, it's a yes or no question.
Correct. Just
Okay.
on the date, not the time, because I don't want to confuse anyone or require UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
Ms. Nestor.
We are, Your Honor.
Zach, please.
She just wasted everybody's time. So now you're not even bringing in the 3. You understand that he's not the witness that any of this should have came in through, which we already knew. And then you want to sit up here instead of just saying, yeah, that if you let everything in, then Dave Norris ain't going to sound like we want it to sound. You're going to sit up here and act like we understand now that he's not foundationally the witness that it should come through. You should have been understood that because the witness already been on the damn stand. The hell? Been in court for 2 hours and the jury ain't been in there yet. Cause you playing. Yeah.
Please have a seat as you come in. All right, have a seat. Thank you. Ladies and gentlemen, thank you for your patience. We will now proceed with additional cross-examination of Detective O'Driscoll.
Okay, I'm gonna stop for a minute because the judge is actually talking over in Michigan. Hold on. And it did it again.
Just indicate which docket number they will be addressing the court on, okay?
Yes, Judge.
This is so crazy that they have to figure this out.
I believe first we will have Ms. Annette Harris.
Annette! No, the fuck.
We're going to come right through the center door, and we're going to go to the side of the courtroom nearest the prosecutor's table there. And you're going to have a seat in this chair directly next to me, and then I'll explain.
Don't piss me off.
Judge, for the record, that's going to be on case ending in 218.
218, thank you.
Yes.
Are you kidding me?
Good afternoon. So, I just wanted to explain a few things to you. That red illuminated device in front of you, yes, that's a microphone. It's also a recording device. And I see that you have a written copy of the statement. Okay. So when you are done, if you could just provide a copy of that, perhaps to the prosecutor's office, so we can make a copy of it. And then you can sit or stand, however you would like to do it. Just make sure that you're keeping your voice nice and loud and clear for us. If you could just first state and spell your name.
Baby.
Annette Harris, ANNETTEHARRIS.
Thank you, ma'am. And there are Kleenex there if needed, whenever you're ready.
To the Honorable Judge Nicholas Hathaway in the Wayne County Circuit Court. I would like to thank the court for giving opportunity to speak and stand here before you to address the concerns that me and my family have. It has been 2 years and 2 months since I reported this I am missing. I want you to know that my life will never be the same. My family's life will never be the same.
Y'all.
And every day that I wake up with her, I wake up feeling depressed. It's another day without her.
That's because when people try to whoop your ass in them streets.
I love her and I miss her dearly. I can't tell her that because her life was.
Wrong judge. What was it, Judge Aaliyah Swanson? Who's the one that called it out that she perjured herself up there lying about Jarvis being up at that house? Shut your ass up. You can't get, since I reported her missing. What about since I lost my baby? Since I couldn't find my child?
Words cannot express just how much me and my family.
Jarvis, just go and tell she knew about it, please. It's the one time you can hand clap out of me, Jarvis.
In my family's life, there are days when I can't, when I don't want to get out of bed. I wake up feeling depressed. I don't want to talk to anybody, to anyone, just getting out of bed.
She's trying to make me knock my own shit over. We saw your testimony. Come on, Laura. We saw your testimony.
That I missed, I'm sorry. I don't want to get out of bed. I wake up feeling depressed. I don't want to talk to anyone. Just getting out of bed to do the basic everyday things that I need to get done. This has affected my health. I am seeing more than one doctor about my health, including seeing the therapist. I don't feel safe in my home. My address and my phone number has been put on social media. People have been driving by, taking pictures of my home. I have been threatened. My family have been threatened.
Big Uncle walked out.
And my family following me in my car. Pictures posted. Setting up GoFundMe raises in the Zion's name without my permission. This has also affected me financially. But
so this is when you can actually get it out? When it's about you? It affected you financially because you lost that check. You ain't said one thing about the unsafe home that you created for this child and cultivated for this monster. They probably got, I know in Ohio, they got a victims of crime fund.
Please remain quiet. Quiet in the court.
Shut the fuck up.
Turn the camera.
Right, an additional reminder, if you're going to have difficulty controlling yourself, now would be a good time to leave.
Sir, can you suggest that?
I'm sorry, were you through, ma'am?
No, Judge, I'm gonna finish reading the written statement for him.
Very good. You can return to your seat now. Mr. Makepeace, you can let her get situated and then you can proceed.
Yes.
All right, whenever you're ready.
Thank you, Judge. I'm gonna go where I remember her stopping. Posting pictures, setting up GoFundMe fundraisers in Nazai's name without my permission. This has also affected me financially, and people doing podcast shows, emailing me, people that I don't know coming to my home, knocking on my door constantly. This is really hard and has been very painful for me, and I pray to God that no one and no other family will ever have to endure what me and my family have endured. This deserves attention and ongoing awareness to other families and people so that this does not happen to anyone and other families like this has happened to me and my family. And that would be the conclusion of the statement from Annette Harris that was provided to my office and that she was reading on the statement.
Thank you. All right, is there any additional complainant that will be addressing the court on file ending 218?
Yes.
Okay, why don't we have that person go next?
It's Shannon Harris.
Are you kidding me? Like, are they really playing?
So again, ma'am, you can make your way right up here.
So I thought somebody was playing a cruel joke on me while we sitting here live for this Jarvis Butts hearing when Annette Harris just pulled what she pulled, but Shannon on her way to the damn stand.
You can have a seat.
I'll be back about this.
However you're most comfortable. Again, that red illuminating device, the microphone and the recording device, just try to direct your voice into that. And if you just state and spell your name.
My name is Marquita Harris, M-A-R-K-E-T-T-A. Last name Harris, Harris.
Thank you. And ma'am, you also have a prepared statement?
Yes.
If you wouldn't mind just providing a copy to the prosecutor's office for the court file following the hearing today.
Okay.
Thank you. Whenever you're ready.
Good afternoon, everyone.
They said Shannon, but this is the twin, Marquita.
3 days since we heard, seen, or even physically touched Ms. I. This has tremendously affected my family and I mentally, physically, and emotionally. Since this case started, we have been physically assaulted in public, cyberbullied, harassed, stalked, and so much more. I became homeless, lost several jobs in the past 2 years. My life, my family life, will never be the same again. You have taken something so precious from us that we'll never give back. Every morning, every day, every month, and every hour, I have to remind myself that my desire isn't coming back. Our life will never
Girl.
be the same. Justice isn't served. You're still able to live. You're still able to get health care. You're still able to breathe without any remorse. You are an habitual serial predator. You have taken my kid's favorite cousin. You have taken my first daughter before I had my own. I hate you. I was nothing but the worst for you. I despise you. My children were removed from my care temporarily because of you. My children's behavior has changed because of you. You have gave the world a whole story to talk about, but today we're here to tell you how this made us feel. justice would never be served. Going back to the house where Desire lived doesn't feel the same anymore. I don't sleep at all anymore. I recommend that the court give him the electric chair if that's what Michigan, if we had it. A life for a life. We will never know her last words. We will never know if she suffered.
Yes, y'all do.
I can't
You know
really
she
say
suffered.
How I really feel to this whole tragic situation.
Ask your sister.
Since January 9th, 2024 will be the day I'll never forget, the day that I got the call that she never came back home.
The audacity. Come on.
I'll never live with myself. I'll never be able to hear her voice. I'll never be able to physically touch her. I'll never be able to see her smile. I'll never be able to.
Y'all didn't want to see that baby smile in the first place. Where's Nazia's mama?
Listen to her, see her smile. I'll never get to see her tell me stories of what her day went on about school. I'll never get to have that chance ever again because of you.
Y'all never took the chance before. Y'all didn't give a shit about that baby.
Hurts.
Okay, Mr. Makepeace, Mr. Lee, who will be going next?
Judge, I believe next would be Miss Kiwana Butts.
And you better get up here and tell the truth.
218.
Tell us why you broke down on that stand, ma'am. Tell us why you broke down on that stand when you looked at your brother, please. Tell us. Otherwise, I don't want to hear from your ass either. Because everybody's going to get up here and try to save their own ass because it's probably still a pending investigation.
So you can have a seat or you can stand, however you're most comfortable. Just state and spell your name first, please.
Okay. My name is Kiwana Butts. First name Tijuana. Last name Butts.
Do you have a prepared statement?
I do not.
That's fine. Okay. Thank you. Whenever you're ready.
I don't have a prepared statement because I had no plans to come here today. I've been battling with myself on what is the right thing to do, what is the wrong thing to do. I'm here today for Nazia and for my nieces and the other victims that my brother has harmed.
You broke down for a reason. I can respect this.
Got up this morning with every intention on going to work because for the last 2 years, I have to go back to that day that I saw a little girl that I did not know, that I had never seen. And I wish that it was a sign that she was okay. And I believe that she was someone else's niece. And I had no reason not to believe what my brother said to me. That day will forever haunt me.
Come on.
Because I go back to like, why was I there? Why didn't I know? Why was there no sign? However, I'm a firm believer in God. And I do believe that sometimes we got put in places that we don't want to be in, even if we don't know why.
Come on.
And I feel like I was put there that day to be a voice for Nazia, and for every other child that my brother has harmed. I believe that Nazia's story brought a lot of the other victims out to the forefront. And sitting in the courtroom today, there are many Nazias, many other victims that are unfortunately being harmed right now at this moment. And people are turning a blind eye to it. People are not paying attention as a community and protecting our children from monsters, from the very people who are supposed to love them and protect them. I don't know
Come on.
why my brother has turned into the person that is in this courtroom today. This is not who I remember as a child. I remember the little boy that used to follow me everywhere, that always wanted to protect me, even though I'm older than him. My brother knows that I've been a victim of sexual assault. My brother knows that I've been molested at a very young age. And he knows the pain it causes. I can't understand why he would want to cause that to an innocent child. Not just Messiah, but to his own children that have his face. I hope that every victim and my nieces and nephews can heal.
They cut it.
All right.
They just cut it.
I don't know why my brother has turned into the person that is in this courtroom today. This is not who I remember as a child. I remember.
Oh no 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 no. Oh no 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 no.
Wanted to protect me, even though I'm.
What happened? Fox to Detroit. You got some explaining to do right now. They cut it. They cut it. I promise I'll go look for another. They cut it. That's the only person that was telling the truth. That's the only person that was telling the truth. That's the only person so far that has had Naziah on the brain. The rest of these people worried about what happened to them, how they lost their kids temporarily. Some kids they can still hug, kiss, be hungry, and be homeless with. They up here worried about how somebody reached out and touched that ass while they was on the street. Rightfully so. I don't condone violence. I'm just saying I understand. You know what?
By the defense. Detective, let's have you come in the courtroom.
Okay. Somebody gonna give it to me. I'm gonna find the rest of it.
Detective, please tell
somebody in that courtroom reached out and touched somebody.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do. Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth?
No objections.
State's Exhibit 3-40 is admitted.
All right. And this was talked about when I believe it was Mr. Kostradimos, I think it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top. Okay. So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's, yeah, Mr. Spacey and in a TV program, right? And those are the three GIFs that were talked about. And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
Right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Kostradimos, yes.
Okay, can you pull up another one of the photos that is the picture from the house? That's it. All right. This is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit? Thank you. All right. And is that also just a closer up view of the legacy mansion?
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better?
What?
All right. Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure. And it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
It's live. I don't see it.
Your
Back
Honor,
on Fox.
objection foundation. I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed, correct?
Maybe I misunderstood the pending.
That's the question.
So I think,
Can we back up a step? Maybe I'll catch up.
sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
They're still talking about West
All the
Bloomfield.
texts from his phone
Yes.
on the day before he died.
Yes.
I don't remember all of them.
I'll
I remember
refresh.
some of them.
So then would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
I don't see anything, guys.
Okay.
I'll go back.
The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more? And maybe blow that up a little, that photo. Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yeah,
So,
Shauna, sorry, objection foundation is the meaning of died, right? He was pronounced dead.
But I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection, his recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I'm just got one more question about the photo and then I'm done.
Doesn't matter if you just got one more.
Question, if we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you're about to
Yes,
ask.
yes. Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo is still up on my screen and the witness is
I apologize. There you go.
staring at it.
Sorry. Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
You just see. Always trying it like a badass little kid trying to get an extra cookie. Annoying.
One more step. If we could go back to 340, which has been admitted, and pull up some additional gifts that were accessed at that same time. If we could pull those up, please.
Sure. There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th.
Yes.
And the one with the champagne is also that exact same time.
Yes.
And the one with the farmer is that exact same time.
Yes.
And we know for sure that the one on the bottom left was sent the day before. Because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect. Thank you. Okay, we can take that down now. All right. I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Cotrudimos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them, and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Foundation.
Foundation, yeah.
Sustained. Lay a little foundation.
Are you aware that there was a search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website,
He's crying.
fair to say that all of those searches are believed
Where
to have
is
occurred
this
after
live where
April
he's
13th,
crying?
2022.
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up, do we have the, do you have that orange notebook exhibit? I can't remember the number of it. Court's indulgence for just a minute. I have the number. I've got it. I'll tell you. Just one moment. I'm sorry, Your Honor. It's hard to keep all these exhibits straight.
Oh, it's on somebody else's page. Okay.
Can we put up exhibit 2-66R? It's admitted, Your Honor. Oh, wait, I'm sorry. Before we do that, can we put up exhibit, 2-66R? That's correct. We don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would he be so kind? I don't want to accidentally put something up that was redacted, Your Honor.
My apologies. We'll fix that. It's okay. One moment, please. Scott, if we do our normal dance, I'd appreciate it. 2-66R, publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kids school notebook, right?
Correct.
Okay, and can you fast forward, Katie, until I tell you to stop? Keep going. Keep going. Keep going. Keep going. Okay, right there. And can you blow out the bottom third of the page? All right, So this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there is an entry that says on March the 22nd. Can you highlight that, please, Katie? Kouri starts counseling. Do you see that?
Mhm.
You need to say yes.
Yes, sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if mental health counselor was part of those, but that's possible.
And I imagine as a, I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator, you've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
Your Honor, maybe
I'll move on. I'm done with that.
You always try to skip out when y'all are supposed to get in trouble.
why we're moving on from the subject matter. No need to approach.
Got it.
We are moving on from the subject matter.
Very good.
And then she gonna say she got another question.
All right. You also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed a Mr. Richins obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it. Yeah. I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you. The second one, 816R, I think. Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that
Scott,
one's got things
would
blurred.
you help us out? Thank you. Let's see. This is 8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Katie does have this one.
Okay.
Yeah, because I'm going to need her to blow it up. Can we
One
switch it back to her, please? I'm so sorry.
No problem.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it, or right under it? Do you see another?
He didn't call it suspicious. And who
loving
gives a
memory
shit? He's not investigating their death.
Right below it.
Yeah, it looks like a program
let me
pamphlet
see.
from the funeral.
Okay. All right.
Yeah, they never put it back on YouTube.
Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. she did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing texts between Eric and Kouri, Katie, if you could pull up exhibit 2 dash, I believe it's 9. 2-3. Thank you. That's it. Before you look at that, do you recall trying to determine, investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
Right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had. I guess it depends on the timing that you're asking about.
Okay, I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination, okay?
Okay.
Can you blow that up? It's exhibit 2-3D as in Delta. And just let him look at all of them, please, just slowly. Give him plenty of time to read.
She gonna piss me off.
Can you go back up? I think we're missing that one. There you go, the next page. Does this refresh your recollection? Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading it.
Oh, sorry. Keep letting him read it.
Yeah, both of those lines are not what we're looking for. Oh my God.
Okay.
Does that refresh your recollection? Do you remember reviewing this series of texts between Kouri and Eric relating to the trust?
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor.
So you trying to make she don't listen. That's the problem. That's the problem with her listening. She hear, but she don't listen.
We're working on something, but I'm going to ask a couple more, move back, and then we may come back to it once she's done looking. So was it your understanding, without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's basically hearsay.
Foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it. There may be some.
Never lay the foundation.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
He just said that everything he saw says she wasn't aware.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. Now I want to talk about Valentine's Day.
And her
You were
being aware
here
still,
when
but not
Ms.
knowing how it
Staking
worked,
testified to
just
the
that she
jury
thought
that,
she could kill him. Are
in a
you goofy?
conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor. Foundation. That's not what happened.
I think
Ma'am.
your, recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion on about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Mistaking from my memory testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor. Is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Make it stop.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay. All right. I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
He's allergic to 5 times the lethal dose. Come on.
She worked for Doreen Kouri cleaning houses with Carmen Lauber.
And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second.
They may have moved back to, yeah, they got both of their lives set on the active
Relevant objection
scene.
sustained. Ms. Nestor, please proceed.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
Thank you. You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
Mhm. Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Cotradimos.
And you also reviewed the phone calls.
Girl, if
I'll
you
strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up. All right, we're almost done.
I'm gonna go back and watch
just to recap,
somebody
a couple
else's
of days
feed.
of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah,
And
or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
They have investigator, right? She testified here.
Yeah.
Okay.
They're a civilian investigator.
Fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Come on.
Other than this, what's in his stomach?
Come on.
Find anything else that had fentanyl in it?
No.
Okay. You can't say how the fentanyl was administered, right?
Orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay. You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company. Have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach her?
She must be at the end because she's trying to reach for it. She's trying to throw and catch a Hail Mary. And then talking about she didn't represent anything to the insurance company. She did if she killed him and up here playing like she don't know how he died. That's why I said yesterday, for me, it's going to be an all or nothing. Either she's going to be guilty of everything or guilty of nothing.
State's objections are overruled. If you would restate that question, if you can, exactly.
I will. And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission.
Because why don't you get that? Because it's about the third, fourth time you said that dumb
Just
shit.
gonna instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection.
And she did
No,
ignorant
not
shit
objection.
with
Let me
it.
approach.
Sure.
Thank you.
I really think she need to go learn to practice her arguments in the mirror. Because you can't think this is helping your client. You can't. Go back to when she just asked him about whether or not Kouri, those texts said Kouri knew about the trust, right? And he said, I can't say what these texts are talking about. I don't know if they're talking about the trust. But she was absolutely so adamant in being right about something that she let this man sit up here and say that Kouri may have been aware of the trust, but she definitely ain't know how it worked. If somebody need money and they know about all the money being in the trust and don't know how it worked, they may be dumb enough
And
they
you
can
were
kill them.
here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was
Probably not Eric,
probably not Eric.
but he could not say that it was signed by Kouri, correct?
Correct.
Okay.
So if Eric didn't sign it, but she got the insurance money, who signed
that's what I
it? You're not
appreciate
even
the
offering
patience.
nobody
Thank
else
you.
that could have
Detective,
signed it.
thank
Who
you. I
signed it?
understand you're the
The kid?
witness.
Mr. Bloodworth, within the scope of cross, please.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Cotrodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you this.
January, zero.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when it charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Cochademos and Ms. Carrington?
Yes.
And is Mr. Cochademos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber
judge gave
that
him
she
30
was
to
something like
65?
the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about, can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know.
And
She
did-
had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And did
We
it
didn't even get into that until well after.
And did it predate any of Mr. Cochademos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office, was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Made my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building.
To this building.
To
or
meet
this
with prosecutors or talk with her attorney here.
Can investigators force someone anyone to speak with them if that person does not want to speak with them?
No.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No, it has to be consent or warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey, it says idiots, idiots everywhere. Is that from the TV show House of Cards?
From my understanding, yes.
Thank you.
She never looked up. Yeah, he'd had to look at me.
I'm sorry, is he finished? We have no further questions. Thank you.
May we release this witness?
Yes, Your Honor.
Mr. Blair.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena. Thank you. Thank you, sir. Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it. So if the state could, I think we marked it as 865. We'll admit that now.
Okay. Can I see it for a moment?
Your Honor, ma'am.
Please. Do you want me to give the Mujisik stipulation of fact preamble and read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. States Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Bloodworth.
Your Honor, state's in an interesting posture.
Do you need a moment on the record outside the presence of the jury?
We do.
Okay.
Because if she get ready to
I
try
think
that
this would be an
bullshit, he
appropriate
said
time to just set
he
a
wants to
schedule
put it
for
out
the rest
first.
of the day. Are we going to be able to? It seems likely to me. You tell me that we'll be taking a recess now, but not coming back for about 90 minutes. Does that sound about right?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay. Well, in either way, I'll bet you a steak dinner. It's going to be about 90 minutes, but we're going to rise for the jury, and I'll send out word through the bail.
All rise for the jury. It's a lot of steaks.
We have lunch coming. I just appreciate it. Have a seat, folks. Thank you.
And you're on.
All right, Mr. Bloodworth, we're on the record. The jury is not present. Tell me what's up.
Your Honor, the state's waiting on the defense's decision regarding the Norris matter, because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses, in the state's case of chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman,
Bond Savage.
Mr. Bondsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for
to
the state
jump
to
in
get
front
into
of
the
it right
case.
now.
Okay, Your Honor.
Unless you want to bring it up first, which
Okay.
in which case
With the state
we
having
might
rested,
do a
Ms.
rebuttal
Lister,
case.
does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or any count thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. In terms of count
So are you
4,
serious?
and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage count 4 insurance fraud is that Ms. Richins, or rather True Stage left the voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl, that Mr. Crozier did not provide fentanyl. Rather, he provided prescription grade oxy. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl.
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level, non-prescription pills we're going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer your Honor's question.
Okay.
Count 3, as I understand it, is that Ms. Richins, again, according to the criminal information, had indicated a phone number with an incorrect digit, the signature on the application.
That's the dealer and his
was Ms.
inventory. Come
Richins'
on, Leslie.
forgery. We talked about count
That's what
5.
we're doing here.
And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree, or
The PO box, circumstantial evidence that Eric didn't know about it.
not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer your Honor's question. Also an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, but I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not
Laura.
coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl. I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, one. Even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else, I believe that the evidence is scant. Your Honor has a question.
No, I'm following.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count one. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000. Well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5. At the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had
29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Lawler for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when she had told Becky Lloyd that she would be better off if Eric was dead. And at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence, in the light most favorable to the state, that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in
that timeline, Kouri, is crazy.
No, Your Honor.
Okay.
Thank you.
That
Mr. Ramos,
timeline
anything
is
further?
crazy. That's why closing's got to put the bow on it, because the timeline doesn't match up when you keep getting this person and that person and this person and that person.
Blood
When you put it like that.
did neglect in my argument initially as to count 2, the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor heard that, so I would just add that for the record.
Understood. Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
5 minutes. Five minutes. He only need 5 minutes. Where y'all think he going with this directed verdict? Do you think he's going to? We've only seen Weinstein get a directed verdict, right? We've only seen Weinstein get one for Yak and YSL. I think that is truly the only time I've ever seen a directed verdict or a judgment of acquittal actually happen. Why did nobody else from there? I'm saying, like, by itself, it's saying, like, what do you mean she was trying to do? Like, who wouldn't want, like, for those of us who do have a credit union and you do get those little cards in the mail that say, hey, just sign this and send it back and we'll just start billing you. And you'll have some, you're like, yeah, a couple extra zeros to help my kids. Okay. Like so you can see that for those of us who are married or have been married or have had a significant other at all. What do men do? Hey, babe, can you? I mean, they don't even fill out their own paperwork for the doctor's office. Okay. If y'all haven't seen that TikTok where that man turned around, look at that woman and asked, was he a veteran? Sir, don't know what to do with the paperwork. Okay. So to an extent, you say, okay, she signed it. They come in the mail, you sign it, you send it back. But then when you add the timeline, and remember, for a directed verdict, it is in the light most favorable to the state. So taking the state's whole case is true, basically, would this be enough to go to a juror for them to be able to make a decision? So when you look at it outside of, I do that all the time. she was telling Josh they was going to be together. She was telling Becky Lloyd he just need to go. She was making plans and looking for substances. So her intention was to defraud. It wasn't just to sign this for my husband real quick. Now we know we are a little bit behind because we were watching the
on each element of the crime.
We were
Counsel is
actually
present, counsel for
watching
defendant and the defendant are present.
the sentencing, which I am going to see if we can find another portion of Fox 2 that has that. Otherwise, we may not be able to watch it, but I'm still going to go find it and recap it. I just may not be able to broadcast it. All right, here we go. Let's see the judge's decision, and I'm sure they probably went to lunch after that. All right.
The issue before the court is defendant's motion for a directed verdict seeking dismissal of counts 1 through 5 in the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied. Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further until before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor.
No, sir.
All right. We'll be in recess until 1 p.m. Just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess.
All right. So we are in recess until 1 p.m. So everybody go get some lunch. Take that in. Directed verdict is respectfully denied. He did not remove any of the charges. He felt like the state put on enough of a case or enough evidence for the jury to be able to decide counts 1 through 5 on their own. So he's going to leave them to it. We are going to be in recess until 3 p.m. Eastern Standard Time because they're going to talk to Kouri to see what Kouri wants to do next. Do you want to put on a case? Because again, Kouri is not obligated to prove a thing. Kouri is cloaked in the presumption of innocence. Kouri does not have to say anything. The burden is solely on the state, and we cannot forget that, despite what the state may have presented, or the things Kouri may have done. So, in this time, Kouri it's about 40 minutes. Kouri needs to decide if she wants to put on a case, and she probably needs to start thinking if she is going to put on a case, what witnesses she wants to put on. Does she want to stir that Dave Norris pot and possibly end up in a rebuttal where Hayden Jeffs and Nick Von Savage's interviews come into play about her? Or do she want to testify? Does she want to bring anybody? Does she want to bring them and testify? Does she want to bring him, and her. She got to figure it out. It's been real. It's about to get real for Kouri. All right, so we will be back with part 2 at noon Pacific Standard Time, 3 p.m. Eastern Standard Time, so we can hop back into it. I'll see y'all in about 40 minutes.